expert insurance people here, we've got clients here, we've got lawyers here, so I think it will be an interesting panel. And joining us, we've got on the first panel, Jeroen van Hoeven, to my immediate right. And then to his right is Michael Sirkin. And then we've got my partner, Ray Masia. And then we've got Jonathan Meir from Wilson Elser. So that's that panel. Additionally, we've got, for the other side of the insurance equation, and that's the obstetrician side rather than the undertaker side. We've got a broker panel who's going to talk about the current state of the market. Hopefully they'll give you some tips on wording and what pricing looks like. But that panel will be chaired by my partner, Diana Kleinman, and then David Henson from McGill and Partners, Stacy Parker from Aon, and Chris Scott from Marsh. So a couple days ago, there was a big snowstorm, and we were worried, maybe we should cancel this program. What's going to happen? The snow will be piled up to the 5th floor here. And then I heard, thank goodness, Jamie Dimon said, it's Monday, and darn it, I'm going to have my conference this afternoon. And he did. So that sealed us a little bit. But then he also said something, which is also germane to today. He said that asset price levels make me feel a little bit like it's 2008. And stop and think about that. Makes me feel like it's a little like 2008. To the extent this program is about securities class actions, the driver behind all those securities class actions is that change in asset value in public market stock prices. So if in fact that feeling that Jamie Dimon put in the paper earlier this week turns out to be accurate, we may be in for a bump or two in the road that may lead to more business for the people on the first panel. And with that, I'll hand this over to Ray Masia and Luma El-Shahid.
Good afternoon, everyone. Thank you for coming out, especially with this weather. So, my name is Luma El-Shahid, as Bill said. I am a shareholder at Anderson Gill, the Insurance Recovery Group, and one of my focuses is directors and officers liability insurance. I will be moderating today's panel. Let me start by introducing our panelists. First, Ray is a shareholder at Anderson Gill. He co-chairs the firm's financial services group. Ray represents corporate and governmental policyholders in all types of insurance recovery matters, including matters involving D&O coverage, professional liability coverage, general liability coverage, environmental and asbestos claims, commercial and crime insurance, and first-party property and business interruption losses arising from natural disasters and other perils. Ray has been recognized by the Legal 500 as a next-generation partner since 2020 and as a rising star in insurance by Law 360. Jonathan Meir is a partner at the law firm of Wilson Elser, where he represents primary and excess insurance companies and serves as co-chair of his firm's insurance industry consulting and drafting committee. Jonathan maintains a particular concentration in coverage for directors and officers, with an emphasis on the growing area of directors and officers coverage with regards to cannabis companies, as well as professional errors and omissions, lawyers, employment practices, and cyber liability programs. He has addressed claims related to shareholder class actions seeking multi-million-dollar damages against public companies and their directors and officers, as well as other high-profile fraud cases involving a variety of issues. And that's on the insurance coverage side. On the underlying plaintiffs and defense securities counsel side, we have Jeroen van Quabechen.
Beautiful.
Would you mind saying it for the audience?
Honestly, you can say whatever you want because the only person here who knows how to pronounce my name is me. It's Jeroen van Quabechen. But again, it's all good.
I'm sorry, Jeroen. I practiced. Jeroen is co-founding partner of JVK Law and is one of the leading shareholder attorneys in the world, widely recognized for his expertise in corporate governance, securities litigation, and breach of fiduciary duty matters. As a respected thought leader, Jeroen is a regular speaker at the law schools at Berkeley, Columbia, and Harvard, as well as important industry forums. He has led and co-led numerous trials in cases involving misrepresentations to investors and breaches of fiduciary duties by corporate insiders, recovering over $4 billion throughout his career. And finally, Michael Sirkin is a partner at Ross, Aronstam, and Moritz. Mike litigates corporate and business disputes in Delaware state and federal courts with a particular emphasis on the Chancery Court. Mike's practice includes a special focus on trying cases arising from mergers and acquisitions and other large corporate transactions. Mike also advises businesses, corporate directors and officers, investment banks, company founders, major stockholders, and other clients in a variety of transactional and litigation contexts, including special litigation committee investigations, pre-suit demands, and books and records requests. And we'll certainly be talking about some of those things today. And, Bill briefly outlined the concept behind this panel. Let me just go into that premise a little more. Today's panel is structured to follow the life cycle of a modern securities litigation event from the very first signs of a corporate crisis to the commencement of the securities class action and a follow-on derivative suit, and ultimately to resolution either by dismissal, settlement, or trial. In our discussion, we're going to be focusing on the interplay between insurance considerations and litigation strategy in the underlying actions. And we'll be moving chronologically through this because in practice, these cases unfold in overlapping but interconnected stages. And we'll begin with the pre-filing stage when a stock drop, restatement, regulatory inquiry, or internal investigation triggers a litigation risk. At that point, plaintiffs' lawyers are investigating, defense counsel is advising the boards, and insurance considerations may potentially be in play. Next, we'll examine how securities class action often sets the stage for follow-on derivative action alleging breach of fiduciary duty against the T's and O's. And we'll also discuss the use of books and records demands before any derivative complaint is filed. And at each stage, we will be exploring strategy from four perspectives: securities and derivative plaintiffs counsel, that would be Jeroen, defense counsel for the company and directors, that's Mike, policyholder side, insurance coverage counsel, which will be Ray, and then finally Jonathan will provide the perspective of counsel for the insurance company. with that, let's jump right in, and we will begin at the pre-filing investigation stage. And so, imagine a crisis event has just occurred. A public company has announced a restatement of financials, or there's been a stock drop as a result of some corrective disclosure. So I'd like to begin with you, Jeroen, as plaintiff's counsel. What tells you that a crisis event is litigation worthy and not just market volatility?
Thank you, and thank you for having me. Can I just make 2 preliminary comments? First one is, I'm going to give you my own views, okay? Not representing clients, partners, or anything like that. And that will also allow me to be speaking more freely, okay? It's just attributable to me. And the second one is, I'm going to make a very clear distinction throughout this presentation, and Luma already started doing that, and I think it's really important to follow along, between the security side and the fiduciary duty side, which is here a tag-along derivative case. So, but we're going to first talk about the security side and then talk about the derivative side. Okay, so I think everybody here is familiar with, third preliminary comment. I do not mind the interruptions. So if anybody has a question, you raise your hand, I will answer it, because really we are here for you. So just speaking for me, if you have anything to ask while I'm speaking, just raise your hand. All right, we have a situation. The situation is there has been a restatement or a significant decrease in the stock price. Everybody here is presumably familiar with the PSLRA, right? Meaning, at that point in time, there is no discovery, there's no lawsuit, there's no nothing. But as a result of the PSLRA, the shareholder bar has professionalized and has its own private investigators, has its own financial analysts, has its own people tracking Bloomberg terminals and things like that. When I talk to my parents, originally from the Netherlands, they don't really know what I do. I'm the first to go to law school and all that. I tell them it's like the SEC with a profit motive, right? And no subpoena power. So what happens when you have a restatement? Well, for everybody who's on the insurance side here, a restatement will be a lawsuit. Okay, let me repeat that. A restatement will be a lawsuit because fundamentally something in the prior financials was wrong. You had to restate. Now, will it be a good lawsuit? I don't know, but there will be a lawsuit. A stock drop, not necessarily so. As Luma was asking, set it up, it could just be market movements. So at that point in time, if you have a very significant stock drop, the first thing that the people at the firm are going to be doing is to say, okay, what did the rest of the market do? Right? Is there like a similar drop? Was there like an announcement of Liberation Day? Was there something like, what was going on? Right? Was there a COVID event? So people start looking at, like, is this stock drop different from the rest of the market? And people start analyzing what kind of disclosures were made right before, right? Are there analysts that say, well, that was surprising, or, our confidence in management is now undermined because they didn't tell us X, Y, Z. So an investigation is starting to start determining whether or not this should be investigated as a potential securities fraud or a 1933 Act claim, like a misrepresentation, right? A prospectus type claim. That investigation will start. But at that point in time, there's not going to be a lawsuit necessarily, right? So it's a different situation. That will change, and everything will accelerate if a lawsuit is filed. Because then you have the 60-day clock that starts ticking under the PSLRA to determine if the party with the largest financial interest will want to move and take the role as a lead plaintiff. So if you don't have a restatement, I think everybody will start looking at it, but the first indication that there's going to be a case is when it's actually filed.
So, Mike, from the perspective of defense counsel, when you have a crisis event that occurs, what immediate steps do you advise the board or management to take? And sorry, before you answer, I do want to just tag on Jeroen's comments. Everybody's opinions here are their own. We do have press on the line, and we welcome questions throughout. So, go ahead.
Thank you. So I will also echo Jeroen's thank yous and his statement that he speaks only for himself. I speak only for myself. To me, I think we have to categorize crisis events. I think when a restatement has happened, that means the company's management and board of directors has already taken some action and believes that it has its arms around the problem to some degree, right? Because you're restating, meaning you think you know what the correct disclosure is today. If it's a stock drop caused by something else, like job one, before I start to worry too much about potential future litigation, is just to do the right thing, stop the losses, whatever might be causing them, start to understand them. And I think the important component to that from a Delaware fiduciary perspective is to start with the most senior people in the company, which most senior from a Delaware fiduciary perspective means board of directors, not officers, and go into groups from there of the most senior people who are disinterested and independent of whatever it is you are trying to get your arms around. So if the problem is accounting or finance related, you might start with the audit committee of the board. You don't want to involve probably your CEO or CFO while you're trying to figure out what happened. If the problem is something else, you just want to get a sense of who are the right people to be trying to understand the problem. Because from a Delaware fiduciary perspective, independence and disinterestedness, not being involved in whatever the underlying wrongdoing is or the underlying problem is more or less the best liability protection you could ever have.
Is it premature at this stage to start thinking about insurance coverage considerations?
I would say it's not premature, it's responsible, but typically from the perspective, as I say, job one is stop the bleeding, triage, understand the problem. Job two is figure out who the right people are to address the problem. Typically those people, from a Delaware perspective, are not particularly concerned with coverage in the sense that, the company is going to pay the legal bills as they start to accrue to understand the problem, and whether that ultimately becomes a covered cost or a non-covered cost, those directors and officers are not indifferent to that, but at the outset, that's not a primary concern.
So let's switch gears and talk about books and records.
I think there's a question.
Oh, sorry.
Is anyone lawyering up yet?
I think absolutely. I think everybody should. I think it should start with, again, who is that group at the company, or really the company's board, who is disinterested and independent and the right people to understand the problem. It does create an issue for lawyers, because a lot of companies will have their existing corporate counsel. And that existing corporate counsel also has to make the same hard decisions that we ask directors and officers to make, which is, are we the right people to investigate this? Or are our longtime contacts, friends, colleagues in the C-suite, just like they're maybe not the right people, maybe we're not the right law firm?
Add one other thing. So one consideration before everybody starts lawyering up is when I start looking at this from the shareholder plaintiff side, if everybody shows up with their own counsel, I'm going to start wondering, what? People not really aligned? Is there really something here? So there's also a signaling function if everybody has their own lawyer from the outside. I'm like, okay, there's clearly something up here.
If I could interject for half a second, I'm on the securities industry side. When there's an adverse event with a company, there's various law firms that they'll be, I know their names, and the phone starts to ring. Do you have any clients who are in the XYZ stock between this date and that date? And they call immediately when there's an adverse event. Small law firms. So it sort of goes into when you talk about lawyering up.
I can give some more clarity on that. So within this is again securities litigation, right? There are a few firms that have monitoring agreements with many clients. And they monitor the portfolios and they make sure that if there's an event, they can advise their clients. Then there are other firms, like the smaller firms, who do not have that. And so they need to start looking at 13F filings. They need to start looking at like talking to people like yourself to try and figure out, would you have a potential client? Quite frankly, if people are doing that, that's not a sign of like confidence, because they're really looking for clients when they don't even know if there's going to be a case.
One step to the side of chasing an ambulance. It's very seldom.
Those are your words.
So, Jeroen, let's talk about books and records demands. First, can you just explain the basics of what factors go into the decision to make a 220 demand?
Sure. Now look, in the hypothetical that we're talking about now and today, we're talking about a tag-along fiduciary duty case, right? A derivative action that tags along to a securities class action. And I will tell you, those are 99.99999% of the time frivolous taxes, okay? They add nothing. There are real derivative cases that would exist independent of a securities class action, where the underlying facts come alight because of the securities class action. Like, I did a case involving a company called First Energy a couple of years ago, and that is still pending because it was a 23F in the Sixth Circuit that I think was successful. There, essentially, the company was accused of bribing government officials, and that caught when that came out. There was a stock drop, there was all kinds of problems, securities class action, but there was also a clear issue on the government side. So, in that case, you have a real derivative case. That's not the hypothetical that we're working with today, okay? So, to answer your question, the 220. So the 220, Section 220 of the Delaware General Corporation Law allows shareholders to pursue investigation into the books and records of the company. But for that, you need a proper purpose. You can't just be a shareholder and say, well, I'm a shareholder, give me your books and records. Books and records, by the way, meaning largely minutes and board materials about a particular issue. So what would give rise to a 220 investigation is something in the news, could be an expose in the New York Times or the Wall Street Journal. It could be a securities class action where you have particular allegations, but you need to have some suspicion of wrongdoing. And at that point in time, you can do an investigation. So just because you are conducting an investigation into the books and records of the company doesn't mean that either your client is committed to doing a case, because if you're already committed, you should not be investigating. And the second thing is, it doesn't mean that there's actual wrongdoing. So as you're thinking about this from the insurance perspective, the 220 for me has a very different function than the fact that you're filing a complaint, for example. You could take the position, and we talked a little bit during a pre-call, you could take the position that in certain 220 investigations, you know, Mike and his colleagues come and they do an investigation and they're like, uh-oh, you know, this is going to lead to litigation that you may think, well, there might be, you know, something that we need to inform the carriers about. But it's also possible that Mike and his colleagues come and say, I don't really see anything because it's only an investigation.
Go ahead.
Another quick question. You're talking about the Delaware Fiduciary law, Section 220. I've been reading a lot recently about both Nevada and Texas trying to have corporations domiciled because they're much more friendly to the corporations as opposed to Delaware, because that's what they say. And I've seen more companies that have been domiciled in Nevada. So basically, does that, this is a relatively question, so practice, is that something that you have to take into account? Because companies may not be domiciled in Delaware. I would assume they're not subject to those fiduciary rules of Delaware.
So both Mike and I have been part of a long-standing conversation about the role of Delaware in U.S. corporate law. And the truth of the matter is Delaware is exceedingly dominant and continues to be dominant in that space because of different reasons, one of which is the networking effect where everybody actually understands Delaware law and understands how transactions are structured and things like that. But due to one of my former defendants, Mr. Musk, who will never be friends, you know, there's this debate. Should companies relocate out of Delaware to Nevada or Texas where he moved Tesla, right? And the honest answer is almost nobody goes to Texas. The idea that Texas would actually be a dominant jurisdiction is frivolous in my mind. There will be more Texas companies because of oil companies that are already there, but I don't see anybody really relocated to Texas. And as a shareholder plaintiff's lawyer, I kind of like Texas. As of now, they're trying to change it. I'll get a jury. You know, I like juries. I like telling stories. So I don't mind going to Texas. Nevada is a different story. In Nevada, they market themselves as the anti-Delaware. Okay, shareholders have no rights. And one of my roles at my firm is I advise large institutional investors, right? They have hundreds of billions of dollars under management individually, right? And they ask me, well, what do you think about Nevada? And I'm like, well, if you like to be ripped off, go to Nevada. But why would you go invest in a Nevada company? Because the agency cost, the monitoring cost of investing in those companies is so much higher. The returns better be higher too. So I don't see a lot of companies actually moving to Nevada unless they're owned by Jim Dolan.
I'm seeing them being formed in Nevada and then doing very deep filings and growing when they start off in Nevada.
Yeah, some of them are, but honestly, it's a minority. Like still 80% of the companies are in Dolan.
It's small, but it's growing.
Yeah.
Yeah, I think quantitatively, I was going to make that same point. Both Texas and Nevada have gotten a lot more press than they've gotten actual corporate domiciles. They've talked about it. They're doing work. They're both serious in their attempt to compete with Delaware for corporate entities, and quantitatively, none has been particularly successful yet. I think still today, the decision for companies being formed is, do we register and incorporate in our home state or in Delaware? That has always been true throughout the course of my career. Increasingly, Texas and Nevada have tried to elbow their way into that conversation. It is a conversation more than it has been in the past, but so far I think that's about all that it is, and I will just echo what Jeroen said from the defense perspective, from the Delaware perspective. I think our goal is always to get the law right. It doesn't mean stockholders should never win a lawsuit. It doesn't mean that companies should never get sued. It means we have to balance the cost of litigation, the frequency of litigation with, as Jeroen talked about, monitoring and the importance of having some enforceable obligations. I will say, I think Jeroen would agree with this, the overwhelming majority of clients, public company directors and officers, really try hard to do the right thing, not because they're afraid of this guy right here or his colleagues, but because they're good people who want to do the right thing. So I don't think we need an abundance of stockholder litigation, but I also don't think that zero is the answer.
Thank you. So we're still at the investigation stage with 220 demands, and I want to shift focus to insurance considerations now, and our two insurance experts. Are 220 demands claims under D&O policies?
I'll respond to you. I mean, that's the best part about when you to be honest, when you work with somebody and on the opposite side, and you can have a real conversation. That's always the best thing to do. So,
well, years ago, Jonathan and I had we did a moot court debate in front of this audience, so we have experience with that, and then we had a real litigation with each other, so it's pretty good.
Yes. So of course, anything when it comes to insurance policy, it all depends upon the wording of it. But there's definitely been a broadening of the definition of what a claim is, and it's usually the ideas of it's monetary, non-monetary relief. And the question becomes: is the 220 investigation seeking non-monetary relief in terms of the request for the corporate records? So it's always best to just, in general, when you get these things, put them on notice on the carrier side to see if they want to preserve that, because a lot of times we're dealing with some of these big events that come on. There are multiple 220 demands. There are potentially multiple securities class actions, and all those things potentially can all be related. So because it's usually connected with the same event. So the answer, of course, depends on the wording, but generally you look for it to be noticed to the carriers to consider it.
So Ray, how do you put them on notice?
Well, one point I want to make is that one of the arguments I've heard is that the 220 demand is not a claim under a D&O policy because it's not for a wrongful act. To be frank, I've never quite understood that argument, particularly when the 220 demand is accompanied by the prospect of a wrongful act. Jeroen was mentioning that there might not be an express allegation of wrongdoing, but there's at least a prospect of it. So I never quite understood that argument. It's kind of a moot point though, because most D&O policies most D&O policyholders can get coverage by including the cost for responding to a 220 demand and the definition of defense costs. Or you could get an extension that provides coverage for those types of costs. I think the thing to be aware of, though, is that when you get an extension, it's typically sublimited, whereas when it's covered as a defense cost, it's usually subject to the full policy limits with the self-insured retention. I think those are the important things to realize. It's kind of a moot point, but I also think it's important to note that, look, particularly when you're seeking to enforce a defense obligation, you don't need proven wrongdoing. You just need the prospect of it, the mere allegation of it. So I've never quite understood that, but it's sort of moot anyway.
And then how do you provide notice to the insurance company? Are there particular considerations that come into play there?
Yeah, so this is actually a really important point. If you get a 220 demand and you consider it to not be a formal claim, or really in any situation, if you don't have a formal claim, everyone knows that you could use the notice of circumstance provision in the policy to at least preserve coverage in that policy period if a claim is later made in a subsequent policy period. We all know that. I think a few things that are overlooked. There are three things that are overlooked. One, you don't have to put an insurance company on notice of circumstance. It's an option. Number two, if you do, it's really important to read the policy and understand what it requires, because some of these notice of circumstance provisions are very detailed, and they require a lot of details about allegations, facts, dates, the nature of the potential claim that could arise out of the circumstance. My opinion is that D&O policyholders should get counsel involved when drafting those things. It's really important. There are cases that address what the requirements are. And third, it's important to understand the consequences of actually submitting a notice of circumstance. If you submit a notice of circumstance, there is the potential that a later insurance company will take the position that because you submitted a notice of circumstance that was accepted by the prior insurance company, any claim that happens in our policy period has to go back into the prior policy period. But that could be a problem if you have an exclusion on the prior policy period that applies to the claim. On the flip side, if you're in a situation like when COVID happened, if you know that exclusions are coming down the pike and you might have a claim arising out of a circumstance like that, it makes sense to use that notice of circumstance. But you just need to be aware of the potential consequences. They're hard to determine and predict, but you can kind of get an idea.
So, Jonathan, when you receive or your client, the insurance company, receives notice, what are some typical defenses that arise in these types of cases? Securities class action, follow-on, derivative action, 220 demand claims.
I guess the biggest thing, of course, is just generally you go through the policies, insuring agreements, and the applicable, potential conditions on it. One of the big things that comes up early on in these matters is who can be the defense counsel for these cases. And a lot of D&O cases are not duty to defend, but they're duty to reimburse. So people can pick their favorite attorneys out there. Sometimes there's a debate, of course, what is the rates to be charged, or following guidelines, because, and those things would benefit everybody involved. I know some people would really dispute the application of litigation management guidelines, but it's for the insured's own benefit because it's saving more of those limits out there. It requires defense counsels to provide more information about what's going on in the case. So all those things can be very helpful. Usually, as I said, with the early part of a 220 demand, there's not much there to know. It's more of you get on notice to say, okay, these are potential provisions that come up, and it's really going to be generally reserving rights to see what may come down the pike as to what a potential derivative or securities litigation can look like. And the insured and the insurer are each understand each other on notice early on as to what are the potential issues with whatever is alleged in the 220 demand itself.
One way to save yourself a lot of headaches, if an insurance company is defending subject to a reservation of rights, you're entitled to your own independent defense counsel, but often the argument becomes, like Jonathan was alluding to, well, what's a reasonable rate? What is the insurance company going to pay? Are we going to pay our standard rates that we pay defense counsel, or are we going to pay the rates that are out in the market? If you have a defense counsel that, a firm that your company likes, it makes sense to try to get them listed on the policy as panel counsel with a negotiated rate in advance, so that you avoid this sort of pre-lawsuit fight about, what rate the insurance company is going to pay. If you're able to negotiate it in advance and set it forth in the beginning, it saves you a lot of headache and time.
Yeah, I mean, endorsements, the brokers here can help work on that. I mean, that's the point. You have a favorite, tell the carrier. I mean, they're not always adverse to it. You'll see it on a lot of other policies and putting it out there. So the more that the brokers can be involved in helping both parties have the expectation of what can happen. It's when both parties have different expectations, that's where their issues arise between the two.
All right, let's move on to the filing of the securities complaint now. And as we go through the process, I'm interested to hear whether the tension between insurance, company counsel, and policy.
There's no tension between us, none.
All right, we'll see. So now let's talk about the securities class action complaint first. What are some key considerations that come into play when you draft that complaint?
All the elements of the securities laws, right? So you basically want to meet all the elements of a securities fraud claim if it's a 10b-5 claim. You do your investigation. You do your loss analysis, your loss causation analysis. You start getting a preliminary sense of what the damages are going to be. You start thinking, okay, how am I going to show that this particular speaker was, CEO, CFO very often, had a culpable state of mind as they were giving this information. So what your investigators will be doing is tracking information flows through the company, who, what, where, when, and how. All those types of things you will need to plead with a significant amount of detail to convince a judge to get over the pleading standards. Now, one question would be, well, what about the insurance, right, given the audience and what you guys are thinking about? Well, at this point in time, nobody has access to the insurance policies on the shareholder plaintiff side, right? We don't have the actual policy. But we do know what types of exclusions are common in those types of policies, right? I mean, look, I'm a recovering coverage lawyer. I was a coverage lawyer later in one case before I became a shareholder lawyer, right? So I know some things about insured versus insured exclusions, bump exclusions, things like that. So we're not going to necessarily plead allegations that will harm the company and the defendants from having a conversation with their insurance carriers by the time that they actually need to pay. So we're not going to plead into an insured versus insured type of exclusion voluntarily,
yes.
Hopefully.
Yeah. So Mike, a securities class action has been filed. Are you worried about derivative spillover?
Yes, typically, and part of this, I should say, since I'm a Delaware lawyer, typically we don't get called until there is derivative spillover. But in the event we are involved earlier, there's a securities action filed. Yes, we are concerned about derivative spillover. Again, depending on the nature of the incident. I agree with Jeroen that at least 99% of the derivative spillover sort of tag-along cases are just attacks that are generally useless, and part of what our approach, at least our effort is focused on, is trying to get those derivative plaintiffs when they file. I think I'm jumping ahead in our outline here, but trying to get them to understand as they are trying to put themselves in the shoes of the company, right? The derivative plaintiff says, I represent the company. I want to recover from the directors and officers the losses that the company has incurred or may incur in the securities action. So part of what we try to get those people to understand who file the derivative case is that it's actually in everybody's interest to minimize that loss in the first place by defending the securities class action.
So do those actions proceed?
Can I just make one point?
Sure.
I don't want to miss this, because Jeroen said something that piqued my interest. He said we don't try to plead into coverage exclusions, and I believe that 100%. But if you take, for example, like objection merger lawsuits, I know that Jonathan will find an allegation in there that can be construed as a bump up. He will find it and he will assert it. So it's unavoidable on the coverage side. You're going to have those issues. Hopefully you get to a good court like in Delaware, where they've determined that a mere allegation of a complaint that could be characterized as a bump up of the price for the acquisition of a company is not enough, right? If an insurance company wants to assert a bump up exclusion, not only does it have the burden of proving that the bump up exclusion applies, but it also has the burden of showing what portion of the loss is actually for a bump up in the price. So while I totally understand that the complaints are not pled into exclusions, Jonathan and guys like him are very creative, and they'll come up with these arguments, and you have to be.
It's not. We're not trying. No one's trying to be creative. All right. We're just going by the terms of the policy itself, and obviously, the main issues that come up on all these matters, in the first instance, is the duty to defend. Is that, and it's a broad duty to defend. So a lot of these kind of issues aren't involved in the onset of the litigations of either the coverage side on the security side or a derivative matter. The question really is the duty to defend triggered, and oftentimes they are.
So can I add two things? So Mike said, look, when you have one of those tag-along, I call them tag-along, these like follow-up derivative cases, Mike will talk to the plaintiff's lawyers on that side, the show lawyers, and say, look, you're representing the company, let's slow everything down, let's not incur a cost that we don't have to incur. I bet, don't know for sure, but I bet that he gets a very willing reception, because the people who file those cases don't really want to do the work. They want to wait until there is a settlement discussion and then route it through the securities class action and say, see, we created this great benefit. Okay, so I don't think that's a hard case for you to make, probably. The second thing I wanted to say is, and this goes to the bump up exclusion because we didn't really talk about the derivative side yet. I follow the bump up exclusion case law very, very, very closely, okay? I think there was a recent case, I think in the Fourth Circuit that came out, it is a critical thing when you're thinking about transactional litigation. And what we do as much as we can is talk about the damages caused by the breaches of fiduciary duty. And we're not doing that because, and this is maybe your comment about creative, I don't want to put words in your mouth. This is not because we believe there is a real bump up that we're trying to achieve. We believe, otherwise we shouldn't file a complaint, that there were breaches of fiduciary duty. So it's not just a matter of creative pleading, it's more like avoiding a mistake, where you do something wrong in a complaint and now people are like, well, it's just talking about a bump up. No, that's really not the reason we brought the case in the first place.
No, thank you. So let's move on now to the motion to dismiss stage. Mike, what factors influence your decision to move to dismiss?
Sure, so it's the flip side of what Jeroen said when he's drafting the complaint. He's going to look at all the elements. We're going to look at all the elements. We're going to find, of course, that they haven't been met. I think there is an important distinction between the Delaware case and the Securities case. I think that the important distinction, there may be motions to dismiss in both.
Yeah.
They will probably read very differently and cover different issues, but it is important in Delaware litigation to recognize, in the Court of Chancery at least, that a motion to dismiss is not always, but often, the last clear chance to avoid a trial or a settlement. It is just not a court that does a lot of summary judgment, at least not a lot of traditional big stack of paper, but I'm going to convince you that these facts are really undisputed summary judgment the way you get in federal court. And so what that means for us is we have to be both very thorough and very thoughtful about what the arguments are on a motion to dismiss. In a derivative case, they will almost always involve something about the demand requirement and the independence and disinterestedness of either the whole board or a committee of the board that considered this issue. But once you get past that point, if a motion is denied in the Court of Chancery, with someone like Jeroen and his colleagues on the other side, we have to start preparing to try the case.
this is a really good point that you're making, because on the coverage side, there are certain pressure points in the litigation where you could potentially get a case resolved. And it might be advantageous to have a settlement before that motion to dismiss even goes up for oral argument. So as coverage attorneys, I think it's important to think about that. At what points in the case can you try to get a case settled? If it's in the interest of your client to settle a case at that point, then I'm going to be arguing that the insurance company has a duty to settle the case at that point, or the insurance company will be responsible for damages that flow by failing to settle. So that's a really good point that you raised. I think it highlights that there are certain aspects of the case where you have one chance to settle, maybe, and that's it. If you don't take the opportunity, then you might never get it again.
Well, I think the most important thing from the carrier's perspective is for the carrier and Mike and his clients to work together. Because the more information the carrier has, and the sooner they have the information, the more money they can set aside for a potential settlement. It's when there is a big disconnect of the lack of information, the lack of transparency as to the potential for successes on these things and evaluation of damages, that is when the insured and the insurers just look at settlement very differently. And when they're not looking at it the same way, it makes sometimes settlement very hard.
Sorry, I was going to add, that is one of the hardest parts of our jobs, not dealing with insurers, but is to be both the advocate who's convincing our clients that we can convince a court that this case ought to be dismissed and everything that he said is false, while at the same time giving an objective analysis to those same clients from those same people about how likely it is that the judge will agree that everything he said is false.
And there are privilege issues too involved, so it makes sense sometimes because it goes to Jonathan's point of working together. Get a common interest agreement, with your client, with the D&O policyholder and the insurance company, where defense counsel can hopefully more freely share information, while doing it intelligently. But these are all things that need to be thought about before these communications happen. But that goes to Jonathan's point of working together to get a case resolved.
Okay, let's move on in the interest of time to discovery. Jeroen and Mike, how do you coordinate discovery when you have the federal securities case going on and the derivative case? Is there one that drives the factual development?
So the short answer is I don't. I have a case to prosecute, and I really don't care so much about what else is going on unless it's going to interfere with my case. So if there is a tag-along derivative case, well, first of all, very, very often there is no real discovery because they're just sitting back anyway. But if there's another case out there that would actually be active, I would follow it, maybe try to get access to it, but I'm just trying to build my own case.
And we on the other side want to be as coordinated as possible because we just don't want to incur costs. We don't have to. I would say on the document side, that's actually easier, certainly than it used to be, and then I actually don't usually need Jeroen's help to coordinate that because once we've done, Jeroen's document production, it's pretty easy to press a button and give that same production to somebody else in a different case, under a different confidentiality agreement, without a lot of extra work. So that part's not hard. Where it gets harder is if both cases are real and both cases get into depositions, because I'm going to say my director and officer clients are only getting deposed once. You guys decide who's going to ask the questions, or you can each ask questions, but it's going to be on this day and in this place. That's where the coordination gets more difficult. I fight as hard as I can for coordination. I understand why Jeroen doesn't want to rely on somebody else in a different case asking questions and building his record. But, as Jeroen said, this is not a frequent problem because the derivative plaintiffs typically are happy to win.
That one thing. So I think you see the dynamic between Jonathan and Ray, right? These guys have known each other for a long time. Well, I've known Mike for a long time. And this is the kind of situation where relationships matter. Because this is the moment where Mike is going to call me and say, really? Are you really going to make me do this multiple times? He used to be a defense lawyer, right, at Latham. You know how hard it is to get this CEO, this person like there and there and there. Can we just work something out here? And the answer is always going to be yes, right? Because then it is a collaborative process. Because in the end, what I want is the facts. I'm not there to obstruct. I want to build my record. And Mike understands that, but he is also busy managing his clients. So we will then work something out. Now, if you have somebody on the other side who is habitually difficult and is not building relationships, then maybe that conversation is not going to be so easy, right? This is one of those moments where human relationships actually matter.
So, Ray, you mentioned privilege issues earlier. Jonathan, you mentioned sharing information and being transparent. How are privilege issues handled, and does that depend on the insurance company's coverage position here?
Not usually. I mean, look, the ideas of, once again, the insurer is along for the ride with the insured. We are part of the defense of this case. The insurer needs to get as much information as they can to evaluate the coverage issue, or the defense issues, the liability issues of this matter. And that comes down to dealing with damages and getting reports from them. And there's, as Ray mentioned, there's common interest agreements, there's, of course, the tripartite relationship. There needs to be the flow of information. And I know there's sometimes resistance to doing so, but if an insurer was going to, slow moving, as you all know they are, needs that time and the data to go figure out how to evaluate it. And the more it drags on, the slower it's going to be, and it doesn't benefit anybody.
Look, there's a real tension here. Obviously, you can see it on this issue because the risk of exposing, your defense strategy to the other side is real, and it's something that needs to be considered. So again, I just think this goes back to what Jonathan was saying. It makes sense to have expectations put out on the table in the beginning. Let's get a common interest agreement that sort of explains exactly how, when, and what kind of information we're going to share. That way you get that little bit extra added layer of protection.
Just one thing. This is surprising to me, and I find this conversation really interesting. I never see discovery from carriers. Ever. Now, maybe I should, but I never do. Because in my mind, there is such a strong common interest that I never serve discovery on carriers saying, well, let me get the defensive strategy or anything like that. What I see very often is a misalignment between some firms, I will not name them, but I think you all know them, that will just milk the insurance as quickly as possible, as far as possible, and then there's nothing left to actually pay claims. I do see a disconnect between interest sometimes between carriers and insurance. But I've never personally, and I don't know if anybody actually has, tried to get discovery about the case through the carriers. So the fact that you guys are very worried about that is interesting to me because I didn't even think of doing that.
We shouldn't have given you any ideas. I would say the privilege issues, at least from my perspective, are typically a solvable problem, like these guys were just saying. I think from the defense perspective, that the ask that typically comes up is just sort of how much, try to minimize the amount. We're happy to share information, not typically concerned about privilege, or at least that's a solvable problem, but let's try to minimize the amount of extra work anybody's asking us to do, because, different firms work and defend cases differently. If we are not typically a, internal memo generating, internal analysis generating, operation, and a carrier comes and says, we need memos and internal analyses, I'm not so much worried about privilege. I'm worried about saying, we only have so much time and there's only so much money in a policy, and we ought to be trying to just win the case first.
I guess, just generally on those 2 points that Jeroen and Mike were making. One, getting as budget as we can from defense counsels is really important. And 2, when defense counsel generates very expensive bills, we would love to see something that reflects that. So the more information we can get from defense counsel to pay his millions of dollars of bills, the better. Because then we feel better. Like, okay, this report, it was worth a couple $1 million. That was very nice. So I think the ideas of the more, as I said, the expectations set early. If the idea of, okay, discovery is going to take 12 months to get this, the document production costs are going to be these. The more the carrier knows about that early on, the better, because they're not surprised, because insurance companies don't like surprises.
Really, if an insurance company is defending, there really is no privilege issue. It's more of a situation where there's a denial of coverage. I mean, I think that's a distinction that everybody can recognize. If an insurance company is defending, there's an alignment of interest. There's no risk of waiver. But you may have a situation where there's a denial of coverage.
Or they've agreed to defend, but they're denying any indemnity obligation.
Correct. That makes sense.
All right, in the interest of time, I'd like to move on and talk about mediation and settlement. Let me ask Jeroen and Mike
My
first.
favorite subject.
Go ahead. What
Nobody's
would you like to say about mediation and settlement? I wanted to ask about global resolutions, but if there's something else that you want to hit on, please feel free.
So, I personally find the mediation and settlement, especially the mediation track, supremely interesting, because this is when everybody's coming together and you see in real time how things play out. Right? You have some of the human elements. Okay, it's Friday afternoon, around 3:30 or 4. Maybe everybody wants to go home. Maybe we'll have a settlement, right? There's that element to it. But then there's also much more substantive element to it, where now I really need to know the policy. I really need to know, okay, what type of claim do we have, and is it covered by the entire tower, or is there some side A only that people are going to say is not into play? Now I have to start thinking about, okay, what kind of exclusions are there? I very often ask the mediator, has there been a reservation of rights? Has there been a denial of coverage? Denial of coverage I know because nobody shows up. But reservation of rights, really? How much can you tell me? And this is also when I start looking, when I walk around the hallways, are they sitting together or are they not sitting together, right? I'm trying to figure out the dynamics between the carriers. I'm trying to figure out the dynamic between the tower and the side A access. I'm trying to figure out, are there multiple towers and is everybody here? So this is what kind of exclusions are in play, because that will then play into what am I going to say if there's a joint presentation. It will play into the assessment of the value of the case, right? How much insurance is there? One of the questions I will ask myself is there a bad faith denial of coverage type argument, right? Am I going to make a demand within policy limits? In the US, there is bad faith denial. Outside the US, there generally isn't. So this to me is like the moment where all these elements, and especially the insurance, become really, really prominent.
Yeah, you've hit on a lot of important issues there. Mike, from your perspective, what are you thinking about?
Sure. So from my perspective, we're thinking first and foremost, whoever our clients are at that stage of the case, typically individual directors and officers, they would like global settlements in all cases, right? Nobody wants to be the last remaining defendant or two in a case that has, funded the rest of your room's litigation, right? Nobody likes to be in that situation. And it's a lot easier for everybody, whether it's a company, whether it's an individual, whether it's an insurance company, to pay the last dollar for global peace than to pay the first, or, fight for all day or day one of the mediation over how we're going to allocate every offer that the defense makes to the plaintiff's room, right? That's a miserable process that we've all been through. So global settlements, we are all in favor of all of the time, and I think, a good mediator is really important.
Oh, that's huge. You've touched on a huge issue, because the mediator has to communicate not only with the underlying parties, but the insurance coverage counsels on both sides, and have everyone's buy-in. And sometimes it doesn't happen. Insurance coverage counsel, do you want to say any last words about mediation, global resolution? And actually, one of the other things Jeroen mentioned was side A and allocation issues.
Well, at first you thought you were going to talk about what room you sit in. Something they usually keep the insurers away, in the fire escape somewhere out there, which is not great, because if you want money, you shouldn't, do that. And I guess, going to the first thing, the question is, are the insurers present or not? I mean, I think, there's optics of that, what that signals to the other side, if you're having them or not, or available. and of course, what the mediator knows about insurance. I think insurance becomes, and potential insurance coverage disputes become potentially a factor in a case. And if the mediator is not aware there's a real coverage issue that's going on, that can, drive a wedge in the whole process. So the more the mediator is aware of those things, if there are, many times there's not. So it's just really going forward as to my question of, is defense counsel giving me enough information for me to make the evaluation as to the value of the case?
Yeah, I mean, if you can't resolve an issue, it needs to be brought to the mediator's attention, because you'll get nowhere in mediation if you don't.
Can I just add one other thing that maybe people on the defense side and the carrier side are not entirely aware of? Very often I come to a mediation and those issues have not been necessarily disclosed to the mediator or have not been resolved at all. And then we go, and then for the first day, kind of all sitting there. And I had a mediation like that not so long ago where everybody flew to California for a mediation. And after about, an hour and a half, this is people from Africa, from all over, sitting there in California. After an hour and a half, it's pretty clear that we're not going to do anything. And then the defense counsel, comes to us and says, well, your claim is really terrible. We're just never going to pay more than X. And sort of blaming us for taking unreasonable positions when it's really clear that there's some kind of coverage issue that cannot be resolved. And the reason I'm flagging that is because it affects the rest of the case. Right? Many of our clients are very sophisticated. Could be hedge funds, could be all kinds of places. They will take that into account, and then the next time they will not show up, or they will have much more significant demand. So I think it's good for everyone. When you see that there's such a coverage issue, just don't have the mediation. Just say, look, we're working things out. Don't do this. Don't make everybody show up. Just try to solve it before.
Good question.
I appreciate all these comments and the process, but especially on mediation, I think different adjusters as well as different carriers may have their opinions on how to do it. When I'm adjusting claims, this is multiple yeah, okay. When I'm adjusting claims and I go to a mediation, my client and I, and defense counsel, we're a team, right? And we present to plaintiff and the mediator as a team. If there are coverage issues, we disclose those to the mediator, usually verbally at the mediation, because mediation statements are usually exchanged. And we may not want those coverage issues to be exposed to the plaintiff at that time, unless, of course, that could affect what they get in the settlement. So it would really depend on what those are. I do agree that they should generally be worked out before a mediation, and you should know what they are and what you're willing to do about them. But you need to show up as a team, but you need to be honest with the mediator if there are issues. And with the plaintiff, if, they have very significant demands that are unrealistic, especially if a large percentage will not be covered with the carrier. And so that's when you can use some of those coverage issues.
That makes sense to me. I would encourage people then to write a confidential sign letter to the mediator. Right? You don't have to wait for the mediation. You can tell them sign.
There was one more question.
Hi, I'm a mediator. So when I'm involved in a situation like this, we always have pre-mediation phone calls, ex parte with all counsel. You can smell the coverage issue. It's there. And if it's a significant coverage issue, you have to have a pre-mediation mediation. So you have to have a pre-mediation, not including the plaintiff, but with the insured, the carrier, and coverage counsel. And you try to resolve the coverage issues prior to the mediation with the plaintiff. So you do a staged mediation. And it's done all the time. So, that's the way to do it.
Thank you very much. I want to thank our panelists. Thank you for coming out. That is our time.